The resignation of Kieron Williams, leader of Southwark Council, is not simply a political reshuffle. It is the culmination of regulatory censure, statutory breaches, and a collapse of public trust in the council's ability to uphold its legal duties. After 5 years as leader and over a decade in office, Williams has announced he will step down in July 2025. But this decision follows a severe regulatory judgment from the Regulator of Social Housing. Legal breaches identified under Section 198 of the Housing and Regeneration Act 2008, Southwark Council was issued one of the lowest regulatory ratings. The RSH found serious detriment in key areas, including breaches of the gas safety, installation and use regulations 1998, fire safety failures under the regulatory reform, fire safety, order 2005, non-compliance with the electrical safety standards in the private rented sector, England, regulations 2020. The council was also found in breach of the home standard, with issues including poor maintenance, widespread disrepair, and dangerous communal areas. These failings may trigger liability under tort law, statutory disrepair provisions, and judicial review proceedings for breach of statutory duty. Admissions of liability. In April 2025, Williams publicly admitted that Southwark had built too many homes too quickly and should have focused on quality. This is legally significant in the context of the Homes, Fitness for Human Habitation, Act 2018, which places an ongoing duty on landlords, including councils, to ensure properties are fit for occupation. Furthermore, the disproportionate impact of poor housing conditions on disabled, vulnerable, and low-income residents raises serious concerns under the Equality Act 2010. Particularly Section 149, which imposes the Public Sector Equality Duty, PSED. A failure to consider or mitigate these impacts may result in legal challenge. Political ramifications. Although a no-confidence motion from the Southwark Liberal Democrats was ultimately blocked, it signaled substantial internal opposition. The motion alleged council tax increases targeting the vulnerable, failure to meet affordable housing standards, ignored environmental targets, a lack of accountability around public safety. These criticisms further exposed the fragility of the administration's political legitimacy. Williams's claimed legacy. The outgoing leader has pointed to achievements including the COVID-19 response, increased free school meals, mental health reforms for children, and a council house building program. However, these policy achievements do not override legal obligations under the Homes Act 2018, the Housing and Regeneration Act 2008, or the Equality Act 2010. Public policy cannot excuse systemic breaches of legal duty. Legal risks going forward. Southwark Council now faces potential judicial review for breach of housing and equality duties, an increase in complaints to the local government and social care ombudsman, civil proceedings under the Landlord and Tenant Act 1985, Homes, Fitness for Human Habitation, Act 2018, and Equality Act 2010, Sections 6, 15, 19, and 29. Any successor to Williams must begin with a full audit of legal compliance, urgent remedial action on housing stock, and transparent re-engagement with affected tenants and legal advocates. Conclusion. The resignation of Kieron Williams is not the end of a political career. It is the start of a legal inquiry. It highlights the growing importance of regulatory enforcement and legal accountability within local government. For claimants, legal practitioners, and housing advocates, this case represents a pivotal moment in the intersection between social justice and public law. For further analysis and ongoing updates, subscribe to www.youtube.com/Civil Rogue Movement 2023. Like, share, follow. The law is not optional, it is enforceable.